Okay, class. Just now we have completed the discussion for the first defense, okay, grounds of defense, which is voluntary non-fit injury. Okay, and then we covered few scenarios, okay, starting from employment and then sports as well as rescue cases. Okay, now we are done with the first one, so let's move to the second one, which is the defense of illegality. Okay, so basically we are going to see what is the defense, okay, what is it all about, and then how it can be applied, okay, in what situation it could be applicable, and also cases, not many cases, okay, maybe one or two or three, okay, not many compared to voluntary for injury. So we are done with the longest, the bulkiest part, okay, which is VNFI. Now we come to the slightly shorter lah, right, in terms of the discussion, okay, in terms of the content. So now the second difference is illegality. Okay, when you do your contract 2 later next semester, you also have this topic illegality, but of course different content, okay, different discussion altogether. All right. Okay, so what is the defense of illegality? Okay, what's the rule? What's the principle about illegality? Okay, so basically, in law, all right, applicable to all civil law lah, all right, applicable to tort, applicable to contract law. Okay, so no court, okay, ought to enforce an illegal contract, or the court, okay, won't allow itself to be made the instrument of enforcing obligations, okay, alleged to arise out of an illegal transaction. Meaning that here, whenever the obligation, whenever contractual obligation, whenever whatever obligation under the law, it involves certain illegal elements. Okay, so the court won't be there to assist. I mean, the court won't interfere, the court won't intervene in order to enforce such illegal agreement, such illegal contract, such illegal obligation. Okay, and we have this legal maxim, which is applicable to both contract and torts law. Okay, the maxim sounds, I mean, this is the Latin, ex tepi causa non orito actio. Okay, it means from a dishonorable cause, okay, from an illegal cause, and action, a legal suit does not arise. I mean, the court won't be bothered to help. I mean, the case will be thrown out of window if the party tries to argue based on illegality or whatever illegal grounds, okay, whatever argument pertaining to illegal things here. What's the reason? I mean, what's the reason of this court's attitude? Okay, basically, it's about serving public interest. I mean, we want to protect public at large. Okay, we are not taking side to the defendant. I mean, especially whenever it involves any illegal elements, okay, pertaining to their act or pertaining to their transaction here. That's the rule. Okay, let's have I mean, let's go further. Okay, how, in what way it could be relevant for our discussion or for our situation of torts law here? All right. So it is applied when the illegality is duly brought to the notice of the court and the plaintiff is himself implicated in the illegality. I mean, the one who asking for compensation, the plaintiff, okay, the claimant, actually he's also implicated. He's involved in the illegal things here. Okay, so we have the case of Scott and Brown. Later we discuss. I mean, this is taken from Scott and Brown basically. And then, all right, on the part of the defendant, because claimant or plaintiff was asking for the court to give him a judgment, okay, the defendant must prove to the court, must establish that the plaintiff conduct or the plaintiff act here is so clearly reprehensible. I mean, blameworthy, deserving blame, as to justify its condemnation by the court. I mean, the court should condemn the act of the claimant or the plaintiff here asking for compensation. All right. And then the conduct is so much part of the claim. I mean, it is so related to the claim, okay, against the defendant. So it justifies refusal of remedy to plaintiff. I mean, the defendant can raise the issue of illegality so that the court will say, oh, no remedy, because why? Plaintiff is part of the illegal things here, illegal transaction or illegal conduct, illegal act here. All right, let's go. I mean, this is example of possibilities in which illegality might be relevant. Okay, extreme example here. Okay, the first one. For example, there are two burglars. Okay, I mean, thief lah. Okay, burglars. The name is A and B. And this A and B, they agreed to open a safe. Okay, or I mean to steal lah. All right, by means of explosive in order to open the safe. right? And in the course of using this explosive, in the course of opening the safe here, A, okay, negligently, remember we're discussing Torts law, okay, negligently handle, sorry about the spelling, okay, handle the explosive charge, okay, and injured B. I mean, the explosive was not properly handled, so it injured B, the partner lah, all right, because they are working together. So now, can be, okay, because he was injured, all right, due to the negligence of the A. So can B take action for the negligence against A here? This is actually negligence, but it involve illegality. Okay, why do you want to open the safe at the first place and you are using explosive? Okay, the main aim of opening a safe here is to do the burglary lah, all right, to do the robbery. Okay, another situation, okay, which might involve illegality as well. If A and B, both of them, okay, they are proceeding to premises, okay, they are moving towards that, and they intend to do the to commit this burglar or robbery, okay, easier, okay, burglarously to enter, and before they enter the premise, okay, the building, the house, whatsoever, B pickpockets A, because after all they are not good people kan, alright, I mean they might do bad things to each other. Okay, so B pickpockets A, okay, picks A pockets, and B steal A's watch. Now, can A sue be in tort? I mean, that one will be under conversion later. Okay, when you learn under torts 2 later. Intentional act lah, not really negligence. Okay, negligence without intention. But both involve a tortious action here. I mean, can they go to the court asking for compensation? All right. So this is an example given by Lord Asquith in National Coal Board and England. Okay, I mean this is an example involving elements of illegality in relation to tortious action or tortious claim. Right? And we have a case actually, okay, which could be similar to this hypothetical example or possibilities here. All right. So it was applied in cases involving joint participants in crime. I mean, both were involved in crime lah. All right. Example of the case, not many cases actually. This is one of the landmark case, Ashton and Turner. Okay. So here, who was defendant, plaintiff here? Plaintiff and defendant, they committed burglary, okay, and they escaped from the scene in a getaway car. I mean, they escaped in the car lah. All right. And then in the process of escape here, they were met by accident. So plaintiff got injured. And then plaintiff, he tried to claim for negligence lah, negligence driving whatsoever. Okay, but he failed because he was involved in burglary. He was about to escape from the scene. So, I mean, later when you learn under contract law, okay, if you go to the court, you must go with clean hands. Okay, if you go with dirty hands like this, the court won't entertain your claim. So here, obviously, because he was involved in burglary, it will be different if he was on the way to school, on the way to work, okay, on the way to whatever thing which doesn't involve illegal things. Of course, he can claim, all right, because this is normal accident case. But here, he was escape. I mean, he was in the process of escape, okay, using a getaway car. So of course, he cannot claim. Okay, I mean, there's elements of crime or illegality here. We have another case, okay, just now 1981. Okay, another one 1990. Okay, Pitts and Hans, another landmark case. It's not Ashton Turner. Now Pitts and Hans. Okay, double T with S. What happened here? So these two friends, okay, plaintiff and defendant, okay, they have some evening drinking at the bar lah, right? Wine drinking, evening drinking. So they set off home on motorcycle. So they rode a motorbike lah, wanted to go home, okay, after they have this drinking session. All right. And then defendant actually doesn't have license, okay, and no insurance, right, to ride the motorbike lah. Okay, and plaintiff was aware of this. Okay, plaintiff has the knowledge, and then defendant, the one who rode the motorbike, okay, doesn't have any license and no insurance whatsoever. Okay, and then because they had a drink kan, all right, so their alcohol level, okay, defendant, the one who ride the motorbike, the level was twice that permitted. I mean, it goes beyond the permitted level. I mean, they drank a lot lah, okay, alcohol. And then they were having fun lah. Alright, I mean something which is quite common in Malaysia kan, those mak rempit lah. Alright, but mak rempit maybe didn't drink kan. Okay, here. So defendant, the one who rode the motorbike, he was encouraged by plaintiff, the pillion rider lah. Okay, he drove in a reckless he rode in a reckless manner. Okay, and hazardous as well. And they were having fun, okay, in order to frighten members of the public. So obviously it's a rempit lah. Alright. And then, as you can anticipate, accident occurred, and plaintiff, the one who encouraged can to drive in a reckless manner, okay, he got injured. So that's why he was suing the defendant. Okay. So in the Court of Appeal, okay, this is the decision. Okay, the court didn't allow the claim. Okay, what's the ground here? Public policy ground. Because why? Well, when they had whatever things having fun here, okay, they were engaged in illegality. Okay, all right, and the court was so reluctant to frame standard of care on the detailed criminal activity. I mean, there's no standard of care whenever it involves anything related to criminal. This is criminal in nature. Because why? Alcohol level was twice that permitted. Okay, and then the riding of the motorbike, no license, okay, no insurance, okay, and then reckless, okay, was done recklessly, okay, hazardously, so it might affect the public. So there's no issue to see what's the standard of care in this situation. Because why? There's elements of crime lah here, illegal, okay, something which is illegal in nature. All right. So no claim for compensation was being allowed by the court. Okay, we have two cases from common law. Okay, we have Ashton Turner, okay, landmark, as well as Pitts and Hans, also landmark case. Okay, in Malaysia, we also have cases relating to illegality. We have at least two cases. We have more, but then this is just example in Malaysia to see what's the application, okay, of the rule. So the first case is Chua Kim Swan and Government of Malaysia, okay, 1994. So it involved taxi driven but without license, okay, without legal license here. So plaintiff, he was the administrator of the estate of the deceased. I mean, it involved the death lah. I mean, the one who drove the taxi died, okay, in the accident. Who was a taxi driver, okay, but when he drove the taxi, it was done without legal license, no license, okay, and then he was involved in an accident and he was killed. But the court said, no, we shouldn't allow the claim. Okay, losses were not claimable because it will be against public policy. So driving a taxi without proper license, so that one is something which is illegal in nature. So whatever things happen later, too bad, you cannot claim. So the court doesn't allow the claim, because if the court allow this claim, there could be many cases in which people won't bother to ask for license, because if anything happen, they can still get the compensation. So here, you cannot get compensation. All right. So that's the case of Chua Kim Swan. I mean, it is related to illegality. Okay, another case. Tay Kian Hock and Kewangan Bersatu Berhad 2002. Here is about repossession of certain item here. Okay, in the picture, spray pump. Okay, I mean it was being on hire purchase, I think. All right, being hired, but then here they try to repossess whenever there's no payment, or it was supposed to be returned, but not returned. So defendant who has the authority, okay, who has the right over the spray pump, they repossess, okay, they try to get it back, okay, confiscate, and then but they repossess the wrong one. I mean, there could be many units, but they took the wrong one, okay, and then they were being sued by the plaintiff. I mean, why you repossess the wrong one? I mean, you took mine, okay, you took the wrong one. All right. So there was a claim for conversion. Conversion is a torts action. Later, you learn in your torts too later. Okay. Claim, in criminal term, it is a theft or theft lah. But under civil action, it is known as conversion. Okay, under torts action. So claim for conversion was not successful because why? Plaintiff conduct. Okay, who's at fault here? Who started the thing here? So plaintiff conduct. Okay, he didn't return the defendant's equipment, which is spray pump. This is actually integral part of the conversion by defendant. I mean, that's the real reason why defendant committed conversion, okay, trying to repossess but end up repossessing the wrong unit, wrong spray pump. So basically, we cannot say, oh, you are totally blameworthy for that, okay. All right, and then the court said, well, you didn't return the spray pump, so we shouldn't allow you the claim lah. All right, it was against public conscience to allow the claim. Conversion was perpetrated by the plaintiff himself. You started the conversion. You didn't return, then you are guilty of conversion at the first place. Okay, had the spray pump not been hidden and available for repossession, defendant would have repossessed without any hassle. I mean, there's no issue of repossessing a wrong spray pump. So there's something which is illegal in nature. I mean, there's conversion involved, okay, at the first place. So you cannot ask for compensation for another conversion because you started the conversion. That's what the court said. Yeah. So this all related to illegality. So go to the court with clean hands. Here, plaintiff, I mean, he didn't return the spray pump. So he went to the court, but with dirty hands, okay, asking for compensation, whereas by right, he should be returning, okay, the pump at the first place. All right, so that's basically the cases on illegality. Not many, okay, only 2 for common law and 2 for local cases from Malaysia. Is everyone okay? I haven't received any warning yet, okay, for the reminder of the time given. Okay, last ground of defense for the part 1, okay, of the topic. Quite straightforward. Okay, inevitable accident. Okay, accident which is inevitable. Accident which cannot be avoided. Because for negligent cases, we have lots of cases involving accident. So one of the defense that the defendant can raise, can argue, is that it happens, but it is beyond my control, so that I cannot avoid from happening. I mean, it could be relevant in some situation. I mean, the court might allow the claim. I mean, might allow the defense so that defendant can escape from liability. Okay, how do we define the word? From sorry, this is the word by Sir Frederick Pollock from common law, obviously. He defined as accident not avoidable. I mean, inevitable mean cannot be avoided, not avoidable by any precautions, okay, as a reasonable man can do. I mean, whatever thing you do to avoid, still cannot avoid, still it happens. So we should allow the defense of inevitable accident, provided that there was precaution at the first place, okay, that was being taken as a reasonable man. Okay, so and then another statement here. Okay, people, all of us, okay, people must guard against reasonable probabilities. I mean, you are supposed to take precaution, but we don't ask you to guard against fantastic possibilities. I mean, number one, you can do precaution, but something which is beyond that, then we should, I mean, the court won't expect people to guard against it. Okay, and then this is another explanation. Okay, an inevitable accident from the point of law is that the party charged with the offense, I mean the defendant, could not possibly prevent, okay, by exercise of ordinary care, caution, and maritime skill. I mean, despite all the caution or the skill taken, still the accident happened. So in that situation, we allow the defense of inevitable accident, but it shouldn't be used lightly. Okay, it shouldn't be abused, okay, in order to avoid from liability. So we have how many cases? 2 cases, I think. All right. Three. Okay, 3 cases altogether. All local cases. Because why? We have many cases involving accident in Malaysia. So in some of the cases, the defendant tried to argue based on inevitable accident. Okay, example of this case, Cik Jah, okay, Cik Jah binti Muhammad Arif and Sissy Scott, 1952, before independence. Okay, so plaintiff, she, I think, all right, was a passenger in the defendant's car, okay, and then the car crashed into a stationary car, and it caused injuries to plaintiff, right? And defendant gave evidence about previous reparation. I mean, the car has been repaired properly, okay, and has been maintained regularly, right? And then brakes also were repaired and tested, and everything functioned so well, okay? So the court held that, I mean, when investigation was being carried out, okay, they found the brake defects, but it was so latent. I mean, so concealed, so hidden, cannot be detected. Okay, latent defects, and defendant here has employed skilled labor, so we cannot put the blame on him. I mean, negligence on his part here. Right? So the defense of inevitable accident was applicable in this case. I mean, not many cases in which they could allow the defense of inevitable accident. Okay, it's so caution to allow this defense. Okay, there must be there must be a strong evidence to show, oh, the car was repaired, okay, the car was maintained regularly, the brakes were maintained regularly. Kan usually we heard in the news, okay, whenever it involve a heavy vehicle, okay, lorries for example, right, usually the brakes were not properly maintained. I mean, they're not repaired or maybe no proper maintenance. That's why it caused accident. Okay, it bump or crash into other vehicle because no proper maintenance of the brake, for example. So this defense won't be available, okay, in that particular situation. Okay, compare with this one. Alright, here for this Tangachima and another flower, okay, the court doesn't allow the defense. I mean, in many cases, the court doesn't allow. What's the reason here? What happened? So, in this case, the defendant's car windscreen, okay, windscreen, it shattered without warning. I mean, suddenly it shattered. And then because of that, it completely obscured his view, cannot see, right? And then because of the shattering of the windscreen, it collided with the cyclist, okay, with the cyclist, and then the cyclist died. Okay, the deceased cyclist. But then the court said that, well, you don't want, I mean, you crash into the cyclist here, but you fail to discharge the honors. Okay, the duty to show, to prove to the court that the cause of accident was a cause not produced by him. Why suddenly your windscreen shattered here? Okay, is it a lack of proper maintenance here? All right, so I mean, the court was not satisfied with the evidence produced by the defendant. I mean, he said, oh, suddenly it shattered. I don't know what happened. Okay, and this is the quotation from the judgment itself here, a long one. I mean, the defendant, he, however, gave no explanation, okay, and then no, I mean, the court was not satisfied, okay, with the explanation, no evidence. That's why the court said, well, we cannot allow the defense of inevitable accident. Actually, it is something which is avoidable if you really maintain, or maybe you were driving so fast, okay, that's why it caused the windscreen to shatter. I mean, you can read the full paragraph lah after this, okay. All right, another case and another one. All right, the last two cases for tonight. Okay, another case, Zainan bin Abdul Ghani and Chong Asen. Okay, it's really nice something. So please just bear with me for another few minutes. So that Zainan binti Abdul Ghani and Chong Aseng, what happened in this case? Here again, I mean, many cases the court doesn't allow the claim. So in this case, the defense of inevitable accident failed because why? Defendant's car knocked down a cyclist, okay? Because the tire suddenly burst. Okay, just now the windscreen suddenly shattered, okay? Because why? The court found defendant negligent in using worn out equipment. Okay, in bahasa we call it tire botak lah. Alright, almost about tire here. And in order to displace the presumption, okay, defendant must prove to the court, alright, that the burst tire is not, I mean, it's not related to your negligence, okay, in maintaining the car whatsoever, your vehicle. So the tire must be properly replaced, okay, after some time. You cannot use bulk tire. You use but at your own risk. I mean, if anything happen, you have to be responsible. I mean, you cannot use the defense of inevitable accident because this is something which is avoidable if you use the proper tire. All right. Here, I mean, in order to allow, I mean, to make use of this defense, okay, the defendant, okay, because defend for the defendant, okay, he must either show what was the cause of the accident and then show to the court possible causes which produce the effect. I mean, what's the real cause of the accident? Is it because of the bulk tire, using the bulk tire here? So this is something which is avoidable, okay, it's not something which is inevitable. Okay, last case for tonight. Sarawak Shell, this is quite recent, 2011. Not that this is but quite recent compared to the earlier cases. Sarawak Shell and the owners of other persons, I mean a long name. The owners of other persons interested the ship of vessel, the red gold of and another action. But you can just quote as Sarawak Shell. We know you are referring to this case. So it involves a collision, okay, between a ship, but not with another ship. Collision, okay, between a ship and offshore oil platform. The platform, like the picture lah. All right. So the issue now, whether the owners, the burden of proof on the defendant to prove inevitable accident. I mean, you have to prove to the court, is it something which is avoidable or is it inevitable? But for this case, the owners of the ship had not established that the accident would have occurred even without their negligence because upon investigation, okay, it disclosed certain defects here. Okay, the defects could have been rectified or avoided by proper securing of the said power card and the system of routine visual checking. So these two were not done. Okay, were lacking. That's why accident happened. I mean, accident could be avoided if this thing were being done, but it wasn't done. All right. So again, so we have three cases in which the defense of inevitable accident fail. Because in this case, the owners of the ship fail to discharge the onus on them, okay, to provide reasonable explanation. I mean, no reasonable explanation. So the court was not satisfied with the proof, okay, or evidence provided by the defendant. That's why the court didn't allow the defense of inevitable accident. So with that, I stop share. Okay, and then I stop recording.